Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello and welcome to the Mayor Brown Employment Podcast. My name is Chris Fisher and I'm the head of the London Employment Group at Mayor Brown. In this episode of the podcast, I wanted to talk about a case that has just come out of the Employment Appeal Tribunal in Scotland called University of Dundee and Chakraborty. It's a case which I think has a lot of practical relevance for in-house legal and HR professionals when you're producing documents that you want to remain confidential because you want to take legal advice on them, either from your in-house legal team or external lawyers. We often see this, of course, with clients who are in the midst of, for example, grievance or disciplinary processes, and before they produce their outcome decision or report, they will want to take legal advice, and so they will want the draft document that they produce to be covered by legal privilege, so that it does not have to be disclosed to the employee until the legal advice has been provided. And specifically, clients will want to rely on the principle of legal advice privilege, which says that communications between a client and their lawyer for the purposes of giving and receiving legal advice are confidential and do not have to be disclosed to anyone else. So the facts in the University of Dundee case were as follows. The claimant, Mr. Chakraborty, was a research assistant at the university, and on the 10th of November 2021, he emailed a grievance about his line manager. At the end of November, the university appointed one of their professors to investigate the grievance. So that professor carried out interviews with witnesses, reviewed documents, and drafted a report which was finalised on the 28th of February 2022. Now that report was not sent to the employee, however. Instead, the following day, on the 1st of March, the university sent it to its external solicitors for them to review, which they did, and the external lawyers proposed some amendments. The professor who'd produced the report agreed with the law firm's amendments, and she added some further amendments of her own. And by the time that had all been done, it was the end of June, so the amended report was finalised and sent to the employee on the 27th of June 2022. So, in the meantime, the employee had issued employment tribunal proceedings, and the hearing of those proceedings was due to come on at the tribunal on the 4th of July. So shortly before the hearing, the university added the amended investigation report into the hearing bundle. Now, the amended report included on the front page a banner which said this report was amended and reissued on the 23rd of June 2022 following independent legal advice. So, not surprisingly, having read that, the claimant asked to see the original version of the report. But the university refused. They said, no, that was a document that is protected by legal advice privilege. Now, importantly, the university conceded that legal advice privilege hadn't attached to the report when it was first produced by the professor at the end of February 2022. But, they argued, privilege attached to the report retrospectively because of the advice that had been given subsequently on the report by the external lawyers. And the basis for that argument was that if the unamended version of the report were disclosed, and then if you compared it to the final version, you could work out what legal advice the lawyers had given because you could work out what changes had been made. So, the EAT decision, well, first of all, the EAT said that it was right that the university had conceded that the original report was not privileged when it was produced. The test for legal advice privilege is that there has to be a communication between a client and a legal advisor for the purposes of the giving or receiving of legal advice. And the EAT said here that that was not what had happened at the end of February 2022. The professor in question had simply finalised her report, presumably for it to be sent to the employee. The university had chosen to send it to their external lawyers for advice the day after it had been finalised. And that really was fatal to the argument, because the court went on to say that privilege could not be attached to the original report retrospectively in the way the university was arguing. They said that any advice that had been given by the solicitors, if they'd given separate advice on the report, plus any draft amended version of the report that the solicitors might have produced, would be privileged. Those things would be privileged. But the original unamended document that the professor had produced at the end of February could not be. And that was still the case even if it was possible to infer the nature of the advice that had been given by the lawyers by comparing the two documents, although the court did go on to say that they thought that that was quite difficult to see how that could be done. So that's the decision. As I say, it's not an unusual situation by any means, although the argument for retrospective privilege is an unusual one. I think here what might have made a difference would have been if the report at the end of February had been produced as a draft, which had been prepared by the professor for the purpose of taking legal advice, either from the university's internal legal team or their external lawyers. Because that's regularly what clients will do during grievance or disciplinary processes. They will prepare draft decision documentation, such as draft outcome letters or investigation reports, with the intention of sending it to their lawyers for review and advice before it's finalised and sent out. And they will want to apply legal advice privilege to the draft that they send to the lawyer. And the difference in the case here was that although the report had been sent to the lawyers, it was sent out the day after the professor had finalised it, and that, the court found, was not enough to create the necessary privilege, because it had not been produced as a draft for the purpose of taking legal advice. It had been produced as the final investigation report for the purposes of the grievance process. And so the golden rule really, I think, for employers that this case emphasises is that if you are wanting to take legal advice, whether internally or externally from lawyers, on documentation that is going to be produced in disciplinaries or grievances or other investigations, that really needs to be thought about and planned ahead of time, so that drafts are prepared in an appropriate way and always with a view to taking legal advice before they are finalised or sent anywhere other than to your internal or external lawyers. Because the other point to remember with this is that it's only communications with a lawyer that attracts legal advice privilege. Communications, for example, between line management and HR will not generally attract that same privilege. So that's the case of University of Dundee and Chakraborty, and that's the end of this episode of the podcast. I hope that you found it useful, and as always, if you have any questions on the case or any other employment law topics, please do contact us in the usual way. Until next time, take care and goodbye for now.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.